Mr. Sweet, seconded by Mr. Jean, moves that Bill C-479, an act to amend the Corrections and Conditional Release Act, in brackets, fairness for victims, close brackets, be now read a second time and referred to the Standing Committee on Public Safety and National Security. Debate. The honourable member for Ancaster, Dundas, Flamborough, Westdale.
Mr. Speaker, it's an honour to be standing here to speak to important amendments to the Corrections and Conditional Release Act that I've proposed in Bill C-479, an act to bring fairness for victims of violent offenders. First, I'd like to thank Minister Taves and Senator Boisvenu for their public support of this legislation this week. I appreciate their commitment, and I'm encouraged by their ongoing leadership to help bring about fairness for victims that we're seeking. Two aspects of this bill, strengthening the voice of victims of violent crime and the proposed increased time between parole hearings, act on the changes that victims, their families, and advocates like the Federal Ombudsman for Victims have urged for many years. It's about time to bring these to fruition, Mr. Speaker. Let's be clear, we're talking about instances of violent crime. I don't think words can ever adequately describe the repulsiveness of these crimes. They're heinous, they're often calculated, and they're always senseless. Mr. Speaker, the reason that it's an honor for me to be speaking here today is because I do so on behalf of my constituents and, tragically, thousands of Canadians like them and the sacred memory of their loved ones. From the time I was elected in 2006, I've had many constituents share their concerns about the imbalance in our justice system between victims and perpetrators. However, my dedication to pursue this kind of legislation was galvanized when constituents of mine asked me to attend a parole board hearing with them in 2010. They wanted their federal representative to see firsthand what the process was like, the voice given to victims, primarily through the victim impact statement. Mr. Speaker, when I agreed to attend, I knew it would be an emotional experience. I was hoping it would also be an educational experience. It was for sure. However, I don't think I could ever have begun to prepare myself for the raw emotion in that room that day. Mr. Speaker, as long as I live, I'll never forget that day. Before even uttering a word, my constituents started to weep. The memories of a crime committed over 30 years previous came flooding back, and the tears were endless. It was a grisly triple murder. Her sister, her niece, her nephew had been murdered by her sister's husband, brutally murdered. After killing his wife, this violent criminal suffocated his two young children, a 6-year-old and a 5-year-old. The murderer meticulously concealed the bodies in the waterways of Hamilton, Ontario. Mr. Speaker, my constituent wrote her first victim impact statement on the eve of the funeral. Over the years, she and her family have insisted on attending the parole board hearings to ensure the voice of victims was heard. They felt an incredible burden, a duty as a family. It was the least they could do to honor the victim, their sister, their daughter, their grandchildren, their niece, their nephew. What struck me like a ton of bricks was the re-victimization, having to deliver the statement over and over, year after year. It was so cruel, so frustrating, and so unnecessary. I watched the family endure the same process again in 2011. Again, triple murder was denied parole. Mr. Speaker, this experience inspired Bill C-479. I set about talking to victims, advocates, law enforcement officials, lawyers, and others to ask what could be done. Beyond the whole issue of re-victimization, I discovered that provisions in the Corrections and Conditional Release Act that may have made sense in the 1970s no longer reflected modern technology and the respect and dignity our system ought to afford victims. From the work my office and I have done in preparation for the introduction of this bill and the experts we've consulted, this bill has sound legal and constitutional foundation, and I believe it will have broad support as well. In tabling C-479 in February, I proposed 9 changes to the Corrections and Conditional Release Act. These are: extend mandatory review periods for parole, whereby if a violent offender is denied parole, the Parole Board of Canada would have to review the case within 5 years rather than the current 2 years. increase the period to within 5 years in which the Parole Board of Canada must review parole following the cancellation or termination of parole. Emphasize that the Parole Board of Canada must take into consideration the victims and the needs of the victim's family to attend hearings and witness the proceedings. Require that the Parole Board of Canada consider any victim impact statement presented by victims. Mr. Speaker, you'd think that this is already the case, that it's a bit of a no-brainer. However, this bill is necessary to enshrine it in law, the victim's voice. Other straightforward changes proposed in C-479 to protect and support victims include requiring the Parole Board of Canada to provide the victim, if requested, with information about the offender's release on parole, statutory release, or temporary absence, and providing victims with information about the offender's correctional plan, including progress towards meeting its objectives. This is one of the things, Mr. Speaker, that Constable Michael Sweet's family, after 30 years of silence, requested, and I'd like to just remind the members of Michael Sweet's story so they understand the depth of feeling in regards to the family and these changes. In the early morning hours of March 14, 1980, brothers Craig and Jamie Monroe entered what was then George's Bourbon Street restaurant in downtown Toronto for the purpose of committing a robbery. Both men were high on drugs and armed with guns. At the time, Craig Monroe was on mandatory supervision from a penitentiary sentence for a previous gun-related offense. The brothers gathered all the people inside into one place, but one of the victims managed to successfully flee. Once out in the street, he flagged down a passing police cruiser. Constable Sweet, who, by the way, Mr. Speaker, is no relation to me, who was 30 at the time, he entered the restaurant and was immediately shot twice. There then began a 90-minute standoff between the Monroe brothers with their hostages and police. The police later stormed the restaurant and both brothers were shot and captured. During the standoff, Sweet was conscious and slowly bleeding to death. He begged his captors to let him go to the hospital. He had 3 young daughters, and he wanted to be with them at home. While Sweet pleaded for his life, they laughed and taunted him. All 3 men were transported to the hospital after the police broke in. Craig and Jamie made full recoveries, and Sweet died a few hours later. Mr. Speaker, other straightforward changes proposed. I should note, Mr. Speaker, that many of the changes I'm proposing in C-479 have been enacted by our Commonwealth colleagues like Australia, New Zealand, and the UK. Mr. Speaker, I believe one of the fundamental responsibilities of the state is to keep our citizens safe. Violent offenders have committed unspeakable crimes. Families have suffered losses that are forever. I hope these changes will help bring a measure of comfort to my constituents and thousands of other Canadian families who have been victimized in this way, who've had their loved ones taken from the prime of their lives, and who live with that pain day after day. The last thing they need is another gut-wrenching re-victimization of a parole system. Mr. Speaker, in closing, please allow me to read a few public comments from the people impacted directly by violent crime. Quoted in the Toronto Star, here's what a victim had to say about extending the review period. Families have already been victimized once. They shouldn't have to be victimized every 2 years. Having to face a loved one's killer and to read what he did to her and how her death has affected our lives is something nobody should ever have to do once, never mind twice. We're asking the federal government to increase the time to 5 years for a parole review instead of 2 years. Mr. Speaker, a journalist in Vancouver province noted a few years ago, Clifford Olson, 70, who seems to take pleasure in re-victimizing the families of those he killed, is automatically eligible for parole every 2 years until the day he dies. Another comment from a victim in Toronto murder case, as difficult as it was to write the victim impact statement, it's also frustrating that we're required to submit it 30 days in advance so that the convicted murderer can read it. Yet we're not allowed to see his material in advance to find out what he wants to say. And finally, Mr. Speaker, an editorial in my own hometown newspaper, the Hamilton Spectator, on March 2nd, 2012. The Parole Board of Canada has a responsibility to the victims of crime. For those victims, the Parole Board is virtually the only source of information about the status of the person who committed the crime against them. Some local victims don't feel well served by the board. That must change. Mr. Speaker, Bill C-479 will give the Parole Board of Canada the tools it needs to do just that. I look forward to the discussion with all members of this House on Bill C-479, this act to bring fairness for victims of violent offenders. Thank you. Merci beaucoup.